Hey, good morning, everybody, and welcome to week three. It is a very cold and very snowy and very icy morning here in Denver, but I did make it into the office today. I know the last two videos I posted, I was at home, but wanted to make sure that you knew that I was gainfully employed and did not just hang out in my sweats at home all day. So I did make it into the office this morning, and it's a bit chilly outside. So, but anyways, wanted to talk a little bit about the reading material for for week three, and just talk a little bit about the assignment for this week, the assignment for this past week, and just give some tips on sort of what I'm looking for and how I interpret the rubric. So, first, with respect to some of the reading materials and some of the things that we'll cover through our discussion questions assignments, and some things we won't, but I want to kind of point out some things to hopefully be as comprehensive as we can be in the few short weeks that we're together in this class. First, the reading material talks a little bit about physician professional responsibilities, and not just limited to physicians, but all licensed practitioners. They're all governed by some state board of health or medicine. Those of you who are licensed practitioners in the class, I think there were a lot of nurses in the class recognize this and know this, that the state board of nursing, there's a certain code of conduct, or there's statutes and regulations that govern the scope of practice, but also what may be considered unprofessional conduct. Certainly for physicians, that's the case. Each state has a definition of what may be considered unprofessional conduct. And if you submit a board complaint against a physician, that would trigger an investigation and potentially more. In discipline for violation of after a hearing of a one of these professional codes of conduct, comes in a variety of ways. It could come in license suspension. It could come in the form of education or public censure, or even up to revocation of a license, depending on how egregious the violation is. I've had two cases. I may have mentioned this already. Two cases early in my career where I represented two different physicians in this sort of issue before a state medical board on complaints related to unprofessional conduct, and both were crazy facts, crazy situations. All I can say about that is, definitely don't ever mess with or falsify medical records. Don't lie to patients or their families. Don't ever make inappropriate comments that to a patient that could be construed as sort of crossing that line of what may be considered unprofessional conduct. Those were very interesting cases. Yeah. Anyways, just moving on. Page 104 in the text talks about patient dumping, and this we've talked a little bit about this already. When there's some sort of duty to treat indigent patients, or patients that show up at an urgent care center, not urgent care center, but a emergency department, and sort of this overlap between what is legally required and what may be considered to be an ethical responsibility or ethical duty. What collectively we think as a society may be ethically appropriate, which is to provide emergency medical care to anyone who shows up, regardless of their ability to pay, regardless of their insurance status, transferred into the form of a law, which is EMTALA, which is the Emergency Medical Treatment and Active Labor Act. And it's discussed a little bit later in Chapter 8, but it certainly imposes certain obligations on emergency departments to provide medical screenings, stabilizing medical care to the patient that shows up without any questions of their ability to pay, no questions regarding insurance status before those two acts, medical screening and stabilizing care, are performed. And then, in each of these EMTALA cases, there are always questions about, what is an emergency department? For some, it's quite obvious, if a hospital has a dedicated emergency department, there's no question about that. But an urgent care center or some other freestanding care center, could that be construed as being an emergency department? And a lot depends on how they market it and how they advertise and their signage and what a reasonable person would conclude that department to be, or that freestanding facility to be. And there are a lot of federal rules. There are a lot of cases that address these situations that sort of guide and direct the arguments in that sort of case. I want to talk a little bit about patient abandonment, and your text talks about this. It's a form of medical malpractice or negligence that occurs when a physician terminates that physician-patient relationship. We talked about, what is the first element of a malpractice or a negligence case? That first element is a duty, and that duty exists when that physician-patient relationship is formed. When that relationship is abruptly terminated by the physician, that could lead to a viable claim of patient abandonment, and that's governed by state law. And it could be, depending on the state, it could be a statute, it could be an actual codified law, or it could just be law based on court cases, which is called common law or case law. There's generally 5 elements. Again, depends on the state, so it may or may not be different in your state. But generally, there are 5 elements. First is healthcare treatment was unreasonably discontinued. The second, the termination of healthcare was contrary to the patient's will or was without the patient's knowledge. The healthcare provider failed to arrange for care by another skilled healthcare provider. The fourth is that the provider should have reasonably foreseen that harm to the patient would occur. So it's that causation element, very similar to a negligence case. And the fifth is the patient actually suffered from harm or loss. So it's actual damages or injury, again, very similar to a malpractice case. So there's slight variance in the first couple of elements from a malpractice case, but otherwise it's very similar. I mean, you got to show causation, you got to show injury. Of course, the cause of action is triggered by different facts. It's where in a malpractice case, it's triggered by that creation of the duty. In a patient abandonment case, it's triggered by the termination of that duty abruptly. And then there are certain other knowledge and knowledge requirements and elements that have to be proved. So I wanted to kind of go through this to show, again, this concept of different elements that have to be proved in order to have an actual case. In this case, patient abandonment, you've got to show all 5 elements. If you're missing one of these elements, there's no patient abandonment. For example, if you can't prove that let's say the provider actually terminated abruptly, failed to arrange care by another skilled healthcare provider, had knowledge or should have known that termination of this relationship would have caused harm to the patient, but there was no actual harm, so there's no causation and there's no damages, then there's no patient abandonment. And so you've got to show in every element, you've got to run through that legal analysis, state the rule, apply the facts, do that analysis, and come out with your conclusion. And only after you've run through this process with each element can you reasonably conclude whether or not, either yes or no, that there's, in this case, patient abandonment or not a patient abandonment. And in the case that we're working on, whether there's negligence or not negligence, or malpractice or not malpractice. Um, so that's an important concept for us to walk through, especially as we get ready for this week 3 assignment on the iTrology case. Um, these are some types of actions that'll lead to liability for abandonment. These are just based on random court cases that I found. Premature discharge of the patient by the physician in a hospital setting. The statement by the physician to the patient that the physician will no longer treat the patient. Refusal to respond to calls, leaving the patient after surgery, failing to follow up on post-surgical care. So those are some things that might trigger a patient abandonment cause of action. Okay, so one other thing I want to talk about, and then we'll talk about the this last week's assignment and this coming week's assignment. I want to talk a little bit about privacy. And next week, in week 4, we'll have a discussion question. We'll talk a little bit more about HIPAA and privacy. But generally, I just want us to kind of get ready for that discussion. HIPAA, which was enacted in 1996, essentially prohibits the use of disclosure of protected. Well, there are 3 components to HIPAA. There's the privacy rule, the security rule, and the enforcement rule. I just want to talk about the privacy rule for a second. And that prohibits the use or disclosure of protected health information unless an exception applies. And there are certain permissive exceptions related to law enforcement reasons and a bunch of others. But generally, the 3 exceptions that mostly providers rely on is the TPO, the treatment, payment, and healthcare operations. So those are the 3 main exceptions. So it's important for you to be familiar with this. And I'm guessing that since you are all in the healthcare industry, you probably go through your annual HIPAA training, at least annually, I'm guessing, and already understand the basics of what is permissible, what is not permissible in terms of use and disclosure of protected health information. And also, the privacy rule also outlines a large list of patient rights in terms of access, in terms of their use, rights to amend, right to view, right to obtain and acquire, right to an accounting of disclosures. So that there are all kinds of different rights that a patient has under the privacy rule. The security rule really is more technical based, and the chief security officer is generally the main IT person at a healthcare provider entity, and it's generally are there proper administrative, technical, and physical safeguards in place to properly protect the protected health information. And the enforcement rule is really the Department of Health and Human Services Office of Civil Rights, which enforces HIPAA, gives them the authority to go out and audit and sanction based on HIPAA violations. So here's the biggest takeaway. Well, not the biggest. That's not right. It's a bit of a hyperbole, but one big takeaway from HIPAA is that there's no private right of action. That means that if let's say I'm at a hospital and someone improperly uses my protected health information, discloses the fact that I'm at the hospital improperly to somebody, I can't go sue the hospital as an individual. So there's no private ability to sue a healthcare provider based on HIPAA. There may be, depending on the state, there may be a cause of action or ability to sue under state law, maybe, but HIPAA doesn't give that. So HIPAA, if my protected health information were violated, I could certainly submit a complaint to the Office of Civil Rights, to OCR, and they would investigate and potentially sanction the healthcare provider, but I don't necessarily have a right to sue and obtain damages under HIPAA, at least. Okay, so that's it for the reading and other material I want to cover this week. There are two things I want to cover. First, the assignment from last week. 1-2 was really the purpose of that, and I told a few of you in your feedback, the purpose of that was to really form the basis, get a good understanding of the facts of the iTeraldi case for upcoming assignments, and particularly for this coming week's assignment. So the facts and circumstances that brought the parties to courts, the facts that raise legal issues are so important for you to know, particularly as we get into this week's assignment. This week's assignment, we're going to analyze the legal issues in the iTeraldi case, and you'll see that in the rubric. The legal components section of that case, to me, what that means is, look at Dr. Ricketson. What are the legal issues? Well, the legal issues need to be broken down by their elements, right? So we've talked about this a few times already. What are the elements of a malpractice case? Well, you got the 4 Ds, as your text refers to them. Each one of those need to be addressed. What is the rule? Remember the IRAC method. What is the issue? What is the rule? Apply the facts, and that's why I keep emphasizing specific facts. Specific facts, apply those to the rule, and then come out with your conclusion. That needs to be done for each one of those elements. After that's done, then you can come to your conclusion in terms of whether or not there was malpractice or not. So that's really important. So the legal components, that's what we need to focus on, the elements, because if the absence of one element, there's no malpractice. So you need to demonstrate that whether or not there are enough facts to support each and every element of the cause of action. The 1-3, the ethical theories and principles from this last week. I think it's great. Those are terms and principles that we need to be familiar with, not necessarily for this coming assignment, obviously, because we're just focused on the legal part of this. If you jump ahead, I forget, week 7 or 6 or 7, we're going to be analyzing the ethical part of this iTeraldi case, and so that's when you're going to want to break out those ethical theories and principles and apply those to the questions being asked. But at this time, we're just going to set those aside, and we're just focusing on the legal part of this. So if you have any questions, please, as always, feel free to reach out to me. You can certainly post something in the general question board, and I'll get to it as soon as I can. But a much faster way to get a hold of me is by text, email, call me, and I'll be as responsive as I can. So anyways, have a great week, and if you have any questions, please let me know. Thanks. Bye.